Okay, and welcome to the dumbest, shittiest, most fucked up, COVID infested podcast that has ever been put together since the dawn of humanity. I am here with an amazing success story guest, Jack Slater. Say hello to everybody, Jax.
Nice to meet everybody. Thanks for having me on.
So I'll give you a little background. So Jack's background is he got into my stuff, kind of ran off on his own, did a bunch of litigation, and then, if I remember correctly, one of the things you wanted to do, because you have kids and stuff, is you wanted to produce educational material on this subject that was more kid-friendly. That was like one of the original messages that I think you sent me, if I remember correctly, way back. Am I remembering correctly, or am I not?
Yeah, and really just simplifying. Like, you throw a lot of information out there, and I thought maybe there's an opportunity to just take this and condense it and make it maybe a little more relatable, add some humor to it, and so not necessarily kid-friendly, but just easier to digest in small bites,
Okay.
I guess you could say.
Good. And I've seen some of your videos. They're very good. They're very fun. They're definitely more child-friendly. That's for sure. And so what we're going to do today is you're going to walk us through a settlement success on this. Before you start that, I haven't had anybody on the show in a long time, so I just wanted to give a quick plug to TM 2025. So for all my audience, the ones that are watching things on a regular basis, they know that I'm working very hard on the rewriting and modernization of TM 2025. I wanted to give a quick plug on that because it's really becoming an incredible document. And I'm going to do a screen share. And if you go to williamsandwilliamslawfirm.com, you're going to scroll down to TM 2000-25 modernized. This is an active page. I'm working on this all the time. This was originally an Army training manual that's all about citizenship. It's an absolutely incredible document, but it had a lot of really old information, and it was written with big words, and it also had a lot of false information about citizenship and the 14th Amendment. It's a numbered course, essentially. And I'm going through each individual number, and I'm rewriting it and cleaning it up and modernizing it, as well as cleaning up any false information as regards to citizenship. But there's a lot of historical information that is being left alone, and it goes by number. It goes to about 176 points, and I've finished the 36 points, so I still have a long ways to go. But I really think that people should be watching this and checking this out and reading this, because this is a lot of the background and historical information that explains why things are the way they are. And even though this document isn't done yet and won't be for quite some time, it's already absolutely amazing. And I think it's going to bring a lot of clarity to a lot of things for a lot of people. And this is being written in a more chill, non-screaming, non-cursing kind of a way, and it's actually going to be converted into a book when I'm done. And this is going to be the first time I've ever written something that can be shared with normal people that are not crazy as fuck. It's not going to have cursing in it. It's not going to have craziness. It's not going to have screaming. It's not going to have any sort of craziness. It's going to be very dialed down. So. And it is even right now. So for anyone who's been waiting and hoping and praying that I produce something a little more on the relaxed end of the spectrum, this is the first time it's ever happened, and it's probably going to be the only time it's ever going to happen. We'll see. But I just wanted to give a plug on that and let everybody know this is incredibly good, incredibly powerful, and it is definitely the next huge evolution in research, and I hope people are closely watching and reading each individual change or adjustments that's occurring, and reading it multiple times, because it's really going to help a lot, and I think it's really important. So with that said,
Excellent.
What I want to do is I want to just transfer into, so Jax, you had a settlement with we're not going to say the company's name, obviously, because when you go through a settlement, right? So when you have a case and you're going through a case, settlements are done privately. And what the definition of privately means, because people like to throw around that word and it makes me so fucking angry, the word privately means that it's not on the docket, right? So for example, let's say a meet and confer. So a meet and confer, like for example, in my jurisdiction in California, it has to be done 7 days before you file a motion, right? So you have a motion, you send it to the other party, you do a meet and confer, you wait 7 days, and then you file a motion, and that's per rule of federal civil procedure 7-3, I believe it is. I could be wrong. I believe it's 7-3. So a meet and confer, you're not telling the court all the details of what happened in that meet and confer. You're simply telling the court that you had a meet and confer. So people say these words like public and private. Nobody has any clue what any of that means. That's essentially what it means. Public, like for example, if you had a settlement talk, that would be private, right? But let's say you are having a deposition. Everything that's said in that deposition, well, actually, no, depositions are also done privately as well. And then let's say, for example, if you're in a deposition and they're not willing to answer the question, you would file in a motion to compel. That would become a docket item. So, question 1, question 2, question 3, question 4. Question 4, they refuse to answer. So now, if you want to, you're going to go and file, let's say, for example, a motion to compel to force them to answer question number 4. Question number 1, 2, and 3 wouldn't necessarily go onto the docket unless there's some reason why you would, or some kind of subpoena you're going to write based off that information. So the idea of public versus private when you get onto a docket is really just, it flows kind of back and forth, right? So settlement, when we're talking about settlement, we're talking about a private arrangement that was basically arranged that settles the case, that allows the case to be dismissed because both parties are in agreement with the dismissal because the settlement was reached privately. Typically in a settlement agreement, you're going to have a, what do you call it? What do you sign a...
MNDA, mutual non-disclosure.
Non-disclosure agreement. So non-disclosure agreement, from all the reports I've gotten, they all look the same, which is creepy and weird and stupid. That means that the bar cards just don't even know what the hell it is. Because the thing is that an NDA, it's like, it should be specific in terms of what you can and can't say, and then there should be like, they're going to say things like disparaging comments, and then
Yep.
No one ever says, well, what's the definition of disparaging? Well, that's just opening the door for a nightmare in your future, because they can basically presume that disparaging means whatever it wants to mean. So, the day that I get handed an NDA is going to be, they're going to get hammered like they've never seen in their entire life, because I'm going to want to know every single definition of every single thing they're talking about before I'm ever going to sign any of your fucking NDAs. But because we have an NDA here in this particular case, we will be referring to the opposing party as defendant in this show, because Jax was the plaintiff, and then we have the defendant who will not be named. And then there'll be certain aspects of all of this that will be either blacked out or not spoken about in order to protect that NDA agreement that Jax has on his settlement. Okay?
Yep.
So with that said, what we'll do is we'll go ahead and have Jax do a screen share and go ahead and start us at the beginning before you even filed the case, if you want to, before you do a screen share, and then go ahead and just by the time you get into telling us about the case, then we'll get into the screen share.
Yeah, absolutely. So, had really picked up on your stuff around December time, when I know there was a lot of ideas coming together already and things really starting to solidify. And I followed closely on the free car group, right? Everybody going in and doing the special endorsement or restrictive endorsement on the security agreement, promissory note, whatever you wanted to call it. I didn't get in on that group, but one of the other options that you had said was, well, just make a couple payments and then ask them for a payoff statement, and then just perform on the payoff statement and tender that back to them, the individuals entitled to enforce the instrument. So I said, okay, I can do that. I paid on the vehicle a couple years, and why not give it a shot? So literally just tried to follow your guidance to a T explicitly with regard to everything I had picked up. I had watched the Joey Kimbrough interview as well, and there was a ton of good litigation advice in there
So
and
so that
how to
must have been
structure the complaint.
December of 24.
Yeah, this past December.
Good.
Yep. Yep.
December of
Exactly. So
24 is when I started to really release all that. I released the negotiable instruments flowchart video was in November.
that helped a ton.
Yeah, I know. It
Absolutely. I've
helped me.
referred to that
I
multiple
still
times.
look at it all the time, so I understand. Okay, so you saw that, and then continue.
Yep, and then figured, why not? How easy is that? Like, that's might as well get the process started and see what happens. And like you mentioned, one of the best things that they can do is give you a formal rejection letter. That's your evidence that they refused your tender of payment and began the breach of contract. So. That's basically what unfolded. What happened is what happens to most people. They reject it and then they damaged the sole proprietorship. That was another thing that I followed in your footsteps and said, hey, okay, I'll be attorney in fact for the sole proprietorship. Sounds easy enough. So I structured the whole complaint around your philosophy as detailed as I could be based on what you had shared so far.
Very cool. So you
Yep.
got a
So
payoff draft.
Yep, so I'll go ahead and share the screen now and we'll start. I've got these numbered so we can just go through them in order of events, basically. So the first thing was right here. This is the payoff statement, which is obviously heavily redacted so we can protect their anonymity. But top right, that was the red stamp, right? Accepted, payable to bearer, signed by the agent for the principal without recourse. And so wrote out and made the value explicit and used registered mail to tender this back to them with a cover letter. I've improved upon this cover letter a bit, but here's the cover letter that was included with the instrument. And I basically said, hey, thank you. I've performed on the presentments, accepted it for value. Please apply the principal's balance to the principal's account. And so I wouldn't necessarily use that language anymore, but this was my thought process at the time. And then I actually tendered two instruments because I wasn't sure which one would be better. So I actually endorsed the payoff statement, and I went ahead and just endorsed the original contract, the security agreement, which is like the promissory note and the deal all wrapped in one, like a 5-page thing. So I had the 1-page payoff statement endorsed, and then I did the same endorsement process to the retail security agreement. And I tendered both of them. Like, hey, take whatever one you want. Keep them both if you want. And so then used Arizona state law, which is in Arizona, it's revised statute Title 47 is the UCC. And so I followed your guidance with not just blindly referencing UCC because it's really enforceable at the state level. So I was very explicit with my components here, reminding them that I'm the holder in due course. And then, oh, by the way, here's a 1099A. I probably wouldn't do that or need that now. I don't think it really applies here, but just, that was one of the things that I thought, why not throw in a 1099A in there? And so told them, if you have a problem with this, I need to hear back from you. Right away. Sincerely, attorney in fact for the principal. So that was step 2. Step 3 was what happens to most people. Hey, sovereign citizen, nice try, swing and a miss. And so we're an acknowledgement of your correspondence, your proposal to use a paper contract as payment. Here's our position, right? And so they essentially tried to throw in some nonsense here. When I actually looked this up, they're not even accurate in what they were saying, but they tried to say that 446004 explicitly permits the assignment of the retail installment contract, notice of assignment to the buyer, blah, blah, blah. We're not accepting your paper contract. Your contract is not a security as defined under ARS 441801. It's like, it's not. I went and looked that up, and actually it is. So I used that against them in the complaint. So
That's
they were wrong
hilarious.
about that. And it doesn't constitute a valid form of payment under UCC 3603. And I beg to differ, right? So then they kind of rejected the 1099A and said that's not appropriate. Why'd you send us that? And
Oh,
then
you got
here's the
vapor
one
money.
that
Beautiful.
yeah, I got the vapor money theory. So redemption and vapor money theory. Your
Working
reliance on
hard. Bar
redemption.
cards, working hard. Here we go.
Working hard. Yep. So this was actually not yet the bar card. This was they replied as the litigation specialist, which later in the complaint they also said they were a loan officer manager. So I kind of tried to call them out on the discrepancy there, but they're the head honcho in the office responded back and said that, we're not accepting that. Here's how you can pay. And we're not indebted to you. You don't have any security interest. It's not exempt from levy. And the lender does not act as a fiduciary or trustee, blah, blah, blah. And, sincerely, litigation department. So I said, great, this is exactly what I need to build my case. And so here's the civil complaint, breach of contract by refusal of tender. So I just used the default forms that Maricopa County supplied from the website. So just followed the instructions, like read the instructions, followed the instructions, used their forms, filled everything out appropriately, and then started into the
Now, real
facts and
quick, you don't
breach
need to. You don't like, for example, someone can go and just find this case and look up the docket. So you have a lot of these things taken off. But the thing is that if somebody wanted to go and find the case, they could just go and find the case and look up the docket. Just as a quick side note.
Yeah, they might have a hard time. I did my best to try to cover up the case number,
Oh,
so
okay.
I don't have that referenced anywhere.
Okay.
You might be able to dig or find it from my previous stuff, but I tried to obscure that as best I could here. But if you get lucky, yeah,
You
you'll be able
obscured
to see
that
some.
for what reason? Not for the NDA, because that wouldn't have
Well,
anything
the
to do with the NDA.
MNDA actually said in there that don't talk about the case or the settlement. I was like, all right, whatever. I'll just be extra careful and not refer to the case directly. So just to kind of cover myself on that, just in case. That's what they meant. I did obscure the case,
Okay.
the case number. So I just started out kind of like you had said. I started with the definitions. Title 47 is defines all the components of the UCC elements that we'll be referring to, and then I executed an agreement with the defendant, which is the Exhibit 1 is a negotiable instrument per 473104. Financed value of the collateralized vehicle, blah blah blah, and then starts the good part really starts here at part 10. So in effort to settle the outstanding obligation in good faith, I requested a payoff statement for loan obligation 302911 in February. In February, the agent properly endorsed the negotiable instrument, order to pay, dated February 20th, valued at $15K per 473109, payable to bearer. So payable to bearer is explicitly referenced here in Title 473109.
Okay.
So I kept that format throughout every step of this. So every one of these is cited by the supporting case law. So pursuant to, oh, by the way, ARS 44-1801, the definition of a security is any note or evidence of indebtedness. So
Beautiful.
it is a security, actually.
Yeah.
And on February 28th, the agent mailed the notice of acceptance that I showed earlier. Intention to settle the obligation using the enclosed instruments, and referred to the document, and then I mailed it to the defendant using the registered mail ID here from Exhibit 4. They got the package, which contained the promissory note and the negotiable instrument, dated February 20th, pursuant to value and consideration, which is defined 473303, and payment 473602A. And then March 7th, I tendered the payment to the defendant, person who is entitled to enforce the instrument using registered mail, once the defendant accepted and signed Form PS 3811. So I had evidence that they signed the green card, and I got that back. Both instruments received by the defendant on March 7th are lawfully defined and qualify as securities per 44-1801, i.e. evidence of indebtedness. On March 14th, the defendant willfully refused the tender of payment received March 7th, rejecting said instruments without presenting any lawful cause nor notice of dishonor. Notice of dishonor is defined at 473503. So defendant's response letter does not include the words notice of dishonor, nor does it mention any particular instrument received nor returned, which dishonor says that they have to refer to the instrument. I gave them two, remember? And they didn't actually refer to either one of them specifically, so that kind of worked to my advantage, maybe. Defendant's refusal of lawful tender of payment automatically discharged the obligation pursuant to Arizona law, which we know is UCC 3603 or 3-603. And if tender of payment of obligation is made, blah, 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 we know that discharges the instrument if they refuse it. And then I threw in some Supreme Court language here and said, pursuant to the Supreme Court's ruling, Guarantee Trust versus Henwood, the plaintiff asserts that there is no longer a legal basis to tender in any specific form of currency, such as gold and silver. Since all debts today are dischargeable by fiat-based commercial instruments, the refusal to accept such tender constitutes unlawful attempt to extort performance in a manner not supported by law. And so here on March 31st, the defendant breached the contract agreement by authorizing prime towing and recovery to repossess the vehicle while the plaintiff was doing business at a customer's location, causing immediate reputational and financial harm. And then acting in dishonor, the further demand for subsequent payment was made by defendant on March 31st with threats of selling the repossessed vehicle if payment wasn't made before the April 10th. And the sole proprietorship was without reliable transportation for 7 days, resulting in total business loss of $1,000 per day times 7 days. The sole proprietorship sustained further losses of $2,500 paid in extortion fees. They made me pay through MoneyGram transfer to get the vehicle back into possession. And the defendant has continued with harassing calls and emails demanding more payments.
Perfect. We're gonna take a quick break right there. Hold on 1 second.
Sure.
Okay.
So the end of the complaint had a section here for the applicable law supporting these claims.
Now, real quick, are we looking at a complaint right now? Or are we looking at something attached to a complaint?
Yeah, this is the very end of the complaint. The default forms that were offered by the county had this page on it where it said you could explicitly
they had like pro se complaint template forms or something.
Yeah, absolutely.
They had
a lot of this structured and already ready to go.
In my appeals at the Ninth Circuit, they have those, but not at the district level. This is state court or federal court? Sorry,
state court.
Okay,
state court. Yep.
All right, keep us rolling here. Applicable law, good.
So the state court allowed me to have this section to just enumerate the laws that I would be citing. So everything that we've already kind of gone through here is just summarized here at the end, including that Supreme Court ruling with Guarantee Trust versus Henwood saying you can't compel in any certain format like gold and silver anymore. So you got to accept all the fiat debt instruments. So I felt like that was a good reference. And then it gets into the injuries, which I wanted to be able to quantify easily. If we did end up in discovery, I could fairly easily prove all of this stuff with the required documentation. So I remember that from your Joey Kimbrough interview with regard to just be clear about your damages and get creative if you need to, but don't go too big. Make it, keep it reasonable, basically. And then the demand for relief was obviously to discharge the debt obligation with the defendant, judgment in favor for damages involving the vehicle's repossession, remove all the negative and derogatory remarks on the credit report pursuant to the Fair Credit Reporting Act, and then immediate injunctive relief from repossession of the sedan. And so that concluded the complaint. Then not much happened for a while. They went into, I filed for an entry of default where you start that window of time where it's their final warning. If they don't reply by the end of that window, then you can actually apply for the default judgment. We got almost all the way to the end of that, and then finally get this email from the bar card that says, "Hey, I've been retained on the case, and my defendant,
a 12B6,
the company here,
typical.
Yep, we're gonna dismiss for the arbitration agreement that exists." And this was actually a big curveball because when I went through my documents, there was no arbitration agreement. I didn't remember signing one. I got a whole stack of stuff with the car when I went home that day, but they didn't give me a copy of the arbitration agreement, which is a little convenient for them because in the arbitration clause it said that you have 30-day window to rescind this. After 30 days, your options to get out of the arbitration are null and void, basically. So it was a really serious arbitration agreement. So I went, oh man, oh boy, is this going to derail my whole argument? So I thought about it for a while and then realized, okay, I've got a couple advantages here. I'm going to reply back and tell them that I'm not I'm not going to fold like a cheap suit. I think you have lack of standing to enforce arbitration. So, hey, I'm nice to meet you. I anticipate resolving the dispute forthwith. And then I went through some case law here from Arizona that asserts, if the name of the company that you signed with on the arbitration agreement is different from the one in the lawsuit, then they're trying to compel arbitration with a different entity. And so that you can't do that per this case law with K-Line Builders and First Federal Savings Bank. Consent to arbitrate with a completely different entity does not constitute consent to arbitrate with defendant. So I pushed back basically and said, go for it. Here's basically how I'm going to reply if you want to. But this is awfully similar to the misrepresentation that you guys got hit with in a different lawsuit, because I had done my homework and somebody else, the state of Arizona, had sued them for deceptive and unfair business practices. So I kind of just threw that out there, like, hey, this is reminiscent of that, and I know what you guys are doing in that case, so don't try to do it here. He was trying to ask if I wanted to talk about it, and I said, no, there's nothing to talk about. But if you want to talk about it, you can give me a call. And so that was my stance. So I didn't hear anything for a while, and then the last day, of course, like they do, when I thought I'd be able to file I actually did jump the gun, and I filed an entry of, I tried to get the default judgment, but they had one more day left to respond. So on that final day, they jumped in and said, hey, motion to dismiss the complaint. And so he did what he said he was going to do, and called the arbitration card, and outlined the background here, and said that we went into an agreement, and he filed an arbitration agreement, and had come up with all this nonsense to try to defend and say that we assigned it properly and blah blah blah. We, per the FTC holder rule. I mean, Barcard went over the river and through the woods to make this argument about, because the buyer stands in the defendant stands in the shoes as the seller, the FTC holder rule applies. I'm like, man, how long did it take you guys to come up with this? Like, I laughed at this. Like, this is great. Like, cha-ching, cha-ching, billables.
Yeah.
Right. And so they go through page after page of why the arbitration agreement should stand. And so you can check that out if you want, but they're basically just saying we want to dismiss the matter because there's arbitration. So I said, okay, great, let's feed that into ChatGPT, and I got a really good response as far as, like, I explained what the circumstances were, the names don't match, give me something. How could I respond? So basically it said, yeah, sure, I got a motion for you. So I cleaned it up a little bit and basically said that the defendant's request was untimely and prejudicial, like they wasted my time, and there's case law to support that that constitutes a waiver of arbitration if you wait till the last minute. I said that they've got material inconsistencies, because the affidavit that they submitted by the individual in the company, they said they were a litigation specialist, but then later they said they were a loan officer, account manager. So I'm like, hey, which one is it? There's inconsistencies here. And then it's not enforceable. I tried to say that the agreement's not enforceable because the names don't match, and yada yada. So the conclusion here is they waived arbitration by engaging in litigation behavior. They misrepresented the internal roles and standing, and they failed to establish any enforceable arbitration agreement. So I asked them to deny the motion. So of course they responded to that. Had a reply in support of defendant's motion to dismiss complainant's complaint, and so they responded to everything that I claimed and said, no, we were timely. You can't dismiss because this was timely. It wasn't procedurally improper, and it wasn't prejudicial towards the plaintiff, and so we didn't waive our arbitration agreement. So cited all this stuff why they haven't waived it. So again, they went over the river and through the woods to build this response to everything that I claimed. They felt like they had to refute all of those, which is like, okay, I must be over the target if they feel the need to acknowledge what I'm saying and try to rebut all of it. So They're just saying again over and over, we didn't relinquish any rights, and regarding the affidavit with the inconsistencies, it wasn't actually inconsistent, and so all these reasons why, again, why the arbitration agreement should stand. So, yep, they went all the way through that, and then at the very end, they asked for the same thing. Reference the FTC holder rule again. We stand in the shoes of the seller, so this is all the same transaction. He can't wiggle out of this because the arbitration agreement was part of this, and so please dismiss the case pursuant to the arbitration agreement. Back to the civil procedure, and grant any other relief as deemed appropriate and necessary. So. Sure enough, boom! Again, I guess I responded again and gave even more. That I just kept him busy, so I tried to respond again and call him out on the legal standard here, and what else? Oh, the payoff statement constituted a new offer to contract per UCC 3306
Mm-hmm.
and A1. And so there's no reference to the named in the arbitration agreement has a different name than on this new contract. So again, why the arbitration agreement shouldn't stand. And so my final thing was, hey, let's go into discovery to prove that they have doing business as registration or corporate merger assignment documentation, successor liability showing that the defendant took on the obligation of the named entity from the arbitration agreement. And so my argument was they don't have standing. Throw out their motion here because I didn't consent to arbitrate with this defendant. I consented to arbitration with a totally different name who happened to be selling the vehicle. So who I was making payments to did not match the name of the company they were related, but it's part of their hustle, I guess, that they do is to sell it under one company name and then you're making payments to a different company name. And so that was the crux of my argument, is that I don't have enough information to prove that they're the same the same entity, and they've not proved that they're the same entity. So deny the motion. Sure enough, the court responded at the end of July and said, "Hey, we've read both. We get it. You're trying to say that there's no valid agreement. A valid enforceable agreement does exist, and neither party is contesting the validity of the arbitration provision. The plaintiff just says that the provision doesn't apply to him because the defendant was not a party to the contract. But the defendant is the legal assignee of the underlying contract. The motion is timely and proper. The present filings do not suggest that either party has initiated arbitration, but the defendant has elected it. So consequently, it is appropriate for litigation to continue unless one party initiates the arbitration proceedings. It's not appropriate for this to be dismissed in the absence of any pending arbitration."
Oh, that's interesting. I like that one,
Yeah,
number 5.
yeah. So they didn't give the defendant what they wanted. They didn't give Barcard what he was asking for, which is a full dismissal. They said, no, we're not going to dismiss. We're going to keep it open, but there is an arbitration agreement. So go run off to arbitration. And if you do it within the time frame, come back and post that you have appeared.
Is there a
and then
time frame that you have to do arbitration? Is there like statute or law on that?
not that I could find, no.
Okay.
The court just said do it before September 30th, 2025.
Oh, they
And if
gave
it's
you an
gonna-
actual, okay.
Yeah, the
Oh, I
court
see right
said
there.
we're going to keep the case open and we're not going to dismiss it. So denying defendant's motion to the extent not expressly granted above. So they gave him part of the request, which is like, okay, you got an arbitration agreement.
It's
Go
interesting.
do
I wonder
arbitration.
if they would have, if for anyone that's in this position getting directed to go to arbitration, if they don't give a time like that, I'm just thinking in my head, it'd probably be a good idea to ask for one from the court, like an injunction, like say, hey,
Yeah.
I'm willing to do this arbitration, but I'd like the court to give a specific date as to when it's supposed to be completed by, in order to speed up the process so it doesn't just get bogged down forever. Because I'm looking at this and I'm seeing that date. That's really nice.
Yeah. So this is when I started doing a bunch of research on this and watching all the videos on arbitration. I went and watched it a couple times. The one that you had with Mansa, where he was a big fan of arbitration, and so I didn't really understand his perspective necessarily on that, because everything that I was coming up with, arbitration is not great. It's a final stance. There's no way to appeal it. Like AAA sucks. And so avoid getting into AAA with at any way you can. And so here I was kind of kicked in the gut, like, oh man, I guess we're going to have to go to arbitration. Oh shoot. So had to reposture a bit and figure out what I was going to do. So that's when I kind of pump faked the arbitration filing. Like nothing happened after this for a bit. Like they didn't send me any docs. It was almost 2 weeks of me just consuming arbitration info that I could so I could be best prepared. And I thought they would send something. But what I realized is through those videos is that whoever has the claim has to be the one to initiate it. So I realized, oh, Barcard is hoping I don't do anything, or he's just waiting for me to to file the arbitration. So okay, what am I going to do with that? So I basically pump faked and said, okay, here's the form for arbitration. I'm about to file it. Are you representing the client? Are you gonna? Does this form look right? And oh, by the way, I'd consider any settlement offers because one of the things that I heard is that arbitration can take forever. You file it and then you pay the fee to ask to go to arbitration with AAA, and then it takes maybe up to 30 to 45 days before you even hear back or get an assignment of okay, your arbitrator has been assigned. Here's the time frame for how it's going to unfold. It could be 90 days or more before the arbitration concludes. And so I realized, oh wow, okay, this could really drag out then. So maybe I could use that to my advantage. I said, hey, here's the arbitration form. I'm about to file it. Should I put you on there? And oh, by the way, we could avoid the dragging this out. I'd consider any reasonable settlement offer. The bar card replied back pretty quick and said, yes, but the client has decided to have us represent them in arbitration. Thank you. And then didn't comment on the settlement offer. I'm like, well, this is, from what I understand, this is kind of the time frame when you get one or you don't, and they're not bringing it up. So, man, maybe they want to go to arbitration because they know that they've got the upper hand, and this will just get, they might get a win and get a judgment against me, and this all could easily go sideways. So then I did end up getting a settlement offer. I let the time go. So yeah, it was a couple weeks, August 15th when I got this, and it was the end of July 29th when the ruling came that like, nope, you're going to arbitration. Get out of here. So I let 2 weeks go by, and then I get this, which was, I joked that this was kind of an insult. He said, let me know if you filed the agreement. Oh, by the way, we'll take you're behind. You're way behind, and you still owe 15K. But my client will take a lump sum payment of 10K, and then we'll forgive the remaining balance of 5,200. You get to keep the car. You sign a mutual settlement agreement, and let me know if this is agreeable. So this is the one that I kind of was like, I was all mad at first when I read this, and I was like, not the settlement offer I was expecting. Like, what are these guys thinking? And then I, calmed down, cleared my mind, and realized, okay, they're at the table. Maybe this is good.
If they sent me this, I would laugh and I would call them and I'd be like, hey, you know what? I'm down for this, but you need to send me back the original note.
Yeah, right. And so I realized, okay, if he's at the table, that's good. I mean, of course, he's the hotshot lawyer. He's not going to just come give away the farm on the first offer. And this is probably just what they do, just to see how I would respond. So I really sat on this for a little bit before I responded in haste, and I wanted to think through all the potential ways to respond to this. And then this is where I said, okay, ChatGPT, maybe I can get some help here. I realized there's something here, the way that he opened this with the opener here is, let me know if you have filed the arbitration demand with AAA. And bar cards, they craft every word, every sentence is very particular in the delivery and the timing and everything. So
Or they just copy and paste some other horse shit. It's one or the other. It's either complete fucking horse shit against the wall and they don't even know what they're doing, or every word is pretty, it's one or the other typically.
Yeah. So I felt like there was something behind this, and I read into it a bit more and realized, okay, this must be a big fork in the road somehow. Like, he really wants to know if I filed the arbitration or not, and that whether I did or not probably changes the strategy a little bit. And then I kind of got a download around, like, billables are an issue here. He's trying to account for the potential billables because he can plan accordingly with the defendant. And so I asked ChatGPT, I'm like, what else can I do here? Maybe the bar card is worried that there's still more stuff I can do. Maybe that's the problem. And he's really hoping that I have filed the arbitration agreement so that they've officially reached that milestone of like, okay, no more billables in court. We can now just plan for arbitration accordingly. So I thought, okay, well, what is that? What could he be worried about? So that's where I leaned heavily on AI and my GPT to say, okay, what else could I do given these are the circumstances? The court ruled for arbitration, but what else could I do? They said, oh yeah, because I thought maybe I could drop the case and start over again. I thought that's way cheaper than going to arbitration and getting a bad deal. Why don't I just file again? Then maybe I can re-argue arbitration. And ChatGPT is like, no, don't do that. Don't do that. That'll weaken your position. They're going to just get you on the arbitration again. The court's going to throw it out because they've already ruled on this, and now you're wasting the court's time. Like ChatGPT was more or less, I get what you're trying to do. Here's your options. I said, okay. I leaned in a bit. I was like, all right, what can I do? And sure enough, it said you can set aside you can rule you file a motion to vacate and set aside the ruling and say that put at constitutionality issues because in Arizona the Arizona Constitution says that you can't you have a right to a jury trial, right, more or less. And so you could use that argument. New information has come to light, and because of that, the judge needs to consider this and set aside the motion. And oh, by the way, if you do one of those, it's pretty common that you get it called in for oral arguments, so you might have to go into court to explain yourself. You could also do a petition to modify. You could still modify your complaint if you wanted to. And I realized, oh yeah, I could make the damages higher, and I could do some other things. And then I was like, well, what if I don't get that? What if I don't get a good result there? And they said, well, if you get both of those motions denied, you could file for an appeal. And here's how that works in Arizona. If you want them to jump on it right away, you could do a special action petitioned appeal. I was like, I didn't even know what that was, but it said that you could do that. I looked a little more into that, and I said, yeah, under extenuating circumstances, if you file a special action appeal, the appellate court like jumps on it fairly quickly. And so I realized, okay, maybe this is what Barcard is worrying about. He's hoping that I don't go and like continue the process in court and try to fight any of this stuff. So maybe I'll use that to my advantage. I thought about how to take everything in that ChatGPT had told me and then craft an email that I could just serve back to the Barcard that is very direct and says, hey, buddy, I know there's more stuff I can do. So that's what I did. I said, hey, bud, the full vehicle payoff was already tendered in compliance with ARS Title 47, Uniform Commercial Code, where the law is clearly established. It's not open to interpretation. I'll be expounding on this further if and when required. Basically saying, like, you think my argument's strong now? Like, just wait until we get to arbitration. I'm going to bury you guys in facts. Like, I'm going to expound so much further than this complaint. So I wanted to insinuate that, like, I'm ready for arbitration if we end there. I said, no, it's not been filed yet. I didn't file the arbitration because the monetary figures you helped me realize that I undercalculated the damages, and I could probably make a fair attempt at a modification per Rule 15A, and I could correct the mistake. And then I could eliminate the compulsory Arizona arbitration if that leave for modification is granted. So small sidebar, because of the value being under 50K in Arizona, the state will actually, they have the ability to compel arbitration because the damages weren't high enough. So I basically said, hey, I can get out of that potential arbitration too if I modify the complaint and make the damages more. So thanks for reminding me that there's actually more damages that I forgot about. Additionally, I can attempt to vacate and set aside the court's latest ruling. It's certainly worth my time, and I've uncovered constitutional grounds for invalidating that arbitration agreement. And that might even be worthy of hearing in oral arguments, right? So win or lose, I learn, and I'd expect to learn much on a special action petitioned appeal, should it come to that. At least the record will be preserved as to keep my options open as possible, because that's something else that ChatGPT said, is that even if you lose all of this stuff, it helps you in the long run because you've preserved the record, and it gives you more of a chance of still having that argument or that appeal down the road. And so I said, look, I told him that I knew everything that I could still do. And I said, while I look forward to going through the motions ASAP, maybe it could be avoided. my counter to your client's settlement offer is I'll reduce to $5,000 in damages paid by the defendant, still release the vehicle lien with DMV, and just eliminate the derogatory credit entries. So I drew a line in the sand, and I came back really firm and said, "This is what I'll take. I don't take your offer, but this is what I'll take." And then within 2 days, so I sent this on August 20th, and by the 22nd, I got this Rule 408 settlement offer, and
Yeah,
they're
Rule
willing to settle
408.
all claims, issues, and
So
disagreements.
real quick on that. Rule 408 means that the whatever's in that letter cannot later be used against them in court. That's what the rule. If you look up Rule 408, that's what the 408 means. Go ahead and continue.
Yep, yep. So what they responded back with this offer, which was really just a regurgitation in full detail of exactly what I asked for. So they didn't change anything. They said, "Okay, we'll give you the 5K. We'll release the lien. We'll remove the credit entries and mark the account as paid. You just got to sign the confidentiality agreement. We'll execute a stipulation to dismiss the case with prejudice. You'll sign an IRS W-9, because we're paying you the $5,000. We want to report that, and then agreement will contain a mutual full release, waiver, discharge of claims, blah blah blah, and the mutual NDA." And so this is the basic outline. They said, it went on a little further to say, "Let us know if you agree." And so I replied back and said, "Yep, I accept this offer." Really simple. And so replied within a day or so to say, "Okay, great, we're done." And then there's the check that came just this past week, and then got this letter just confirming on September 5th that we're done here. They said, "We have closed your account September 4th. We fixed the credit issues. It may take them a little while to update, but we've closed the account with Experian. We've released the lien, and you should be able to contact the DMV to get the title." I did get the title on Thursday or Friday. I saw the picture of it show up in my mailbox. I just have to go get it. And then the settlement payment, which I showed just a second ago, was the check FedEx to you on September 5th. And so I got that the next day. And then the dismissal, they did enter the dismissal, the stipulation to dismiss, which I had signed. So I had to sign the confidentiality agreement and that stipulation for dismissal first before they would do any of the stuff that they promised. So I read over everything. It looked good. Signed it, executed it, sent it back, and then sure enough, they followed through. And then this now fully concludes this matter. So that was it. It was over basically on September 5th.
Wow. Did you ever do any in-person hearings?
Nope, never had to do an in-person hearing on this.
Did you ever do phone calls with the defense counsel?
Nope. He asked, and when that very first email said, "Hey, we're gonna compel arbitration because you signed an arbitration agreement. You want to call me and talk about this?" I was like, "We don't have anything to talk about, bro." I wonder what would have happened if I did call back. But I figured it would just be an opportunity for them to try to intimidate me or whatever. I didn't imagine that call going well, so I just decided to push back and immediately start showing them that I knew how to respond if he was going to file something like the dismissal.
Yeah, it's amazing how easy this was for you. I'm kind of
Yeah.
amazed. I'm a little bit
Yeah, but
amazed.
kind of like in your experience, it's like the courts just do not want to have this argument. They don't want to talk about it. They don't want, like, they obviously weren't that confident that they would win in arbitration, even though 4% of plaintiffs win. That was the statistic. I don't know how they got that statistic, but they said only 4% of plaintiffs' complaints win in arbitration. So the defendant, it's heavily slanted in the advantage of the defendant that compels, or whoever is protected by an arbitration agreement in their contract, and they compel it, the favor is to them. So you almost never win in arbitration, and it could go sideways, and you end up getting a judgment against you. And even though they're all lawyers and bar cards, I thought that they would be pretty confident that they would win if it went to arbitration, but it seems like maybe maybe not. And maybe because they don't hear this argument very often, or they don't have any other comparisons for which to contrast and compare. Like, okay, people, this goes to arbitration every so often, and then usually this is how it goes. I don't know. It's all speculation, but it's interesting that they did not want to take their chances in arbitration.
Hmm. Go ahead and stop sharing the screen for a moment.
Sure.
So, how long was the whole process start to end?
Start to finish, I think I requested the payoff statement and tendered it like mid-March. They damaged me, end of April, and I filed in the end of May. And then things really started heating up towards the end of June. So the end of June and July is when the boxing match happened with Barcard, and then it officially wrapped up and got the settlement check September 15th. So just
That's
a week ago or so.
crazy fast. That's crazy fast. I mean, I don't know of a lot of other people who are having such an easy time as what you had. So I don't really want people to think it's going to be this easy, but I'm just wondering how or why. You were only asking for $5,000 even from the beginning, right?
No, 30,000. The damages were well, yeah, 30, 27 or 30, I forget what it was. I think it was 27. So 27 is what was in the complaint. And then I threatened to make it even more when we were going through that little tiff back and forth after they came in with their insult offer. I said, hey, I can go even higher and exceed the 50K threshold so that you don't even have the chance of compelling state arbitration at that point. And then that's when I figured, okay, if they came in with their insult offer, what if I came way down and just made it reasonable? Because candidly, I just wanted to prove a point. I would have probably been happy with them saying, no, we're not going to pay anything, but we'll discharge the lien. I'd be like, sold.
Okay.
But I thought, I don't want to leave any money on the table, so maybe I can get at least 5K out of it. And then they accepted it promptly.
Yeah, because it only cost them $5K. Because it doesn't cost them anything to have the car. To give you the car. So what would you recommend, or what would you say was the big contributing factors towards you getting this done?
Probably in the complaint where I was just meticulous about every step of the process, kind of like when one of your podcasts, you had talked about, like, I don't even care if I get a judgment in court for $1 million, here's what I would do. Defendant has received the negotiable instrument, per UCC. Defendant has endorsed with a qualified endorsement payable to Brandon Joe Williams, pursuant to UCC. Now, look, the defendant is tendering the instrument back to the court. Like, you literally just went through every single step. And I thought, okay, I'll just do that, and I'll break out every single thing that happened in its own line, and each thing will be supported by the UCC or state equivalent of the UCC code. And so I think I made it really hard for Barcard to rebut any of those, because when you look at the facts and you look at what the law says, like, prove that that's not how it is. That not what it says? Like, is that or isn't it what it says? It is, isn't it? And so I probably just put them in a really difficult position because of how the complaint was worded. And then I proved early on that I was a formidable opponent with my responses. And I was probably not your average pro se litigant, given how well and thorough I was able to counter their motions and just keep them busy. And then continue to prove that, like, hey, I know there's more stuff I can do. We don't have to go to arbitration yet. I can do all these other things and run up the billables, and then we'll go to arbitration. So is that what you want to do? Because I have no problem with that. And I think that threat was like, no more court stuff, then still have to maybe lose in arbitration. No, let's just give him what he wants. And so that's probably what led to it working in my favor.
Well, you do exactly what I teach. You're one of the first guys to have success. I've heard a little bit of things here and there, but I haven't really confirmed anything the way that I've confirmed your situation. get that payoff sheet, endorse it, tender it back with the cover letter, get rejected, and then file a civil case in state court and use the state version of the UCC. They filed a motion to dismiss, which is probably what's going to happen to anyone doing this. You responded to it in opposition. They replied to your response. You put up a fight against the arbitration agreement. The court, I think, did a great job of giving them arbitration, but also giving them a date to when the arbitration has to be completed. I feel like that would make me a lot more comfortable if I got forced into arbitration, if there was a date where you had to report back to the court or a date where it had to be completed by, to speed up the process so it doesn't wind up being, 6 years or whatever. Asking originally for $30K and then bringing it down to $5K, it makes sense because it costs, $5K just for a handful of filings to pay a bar card. So by working with them and coming down to the $5K, I think that's something that I don't see people do a lot. I think people want violence most of the time. So there's I think that's kind of a unique thing that you did, which is something I'm going to be doing more. Actually, I had already decided that I'll be doing that more. You'll be seeing that in my credit reprogramming case that I've been talking about forever. That's coming up slowly here. It's probably going to get
some
filed.
of the ones I've seen that didn't work, some of the cases and what people have shared with me directly, either on a consultation or like, hey, I got pulled into arbitration and they ruled against me. One of my clients said, and they really came down to not being able to confirm, like, you weren't damaged. They might have refused your instrument, but how were you damaged? And so I think the fact that I had clear and present damages that were quantifiable and reasonable against the sole proprietorship, like maybe the fact of those combination of things, the fact that it's not just me, like I wasn't saying I was damaged, I was saying the sole proprietorship was damaged, and here's exactly how and why the sole proprietorship was damaged. So there were, back to your other podcast with Joey, where it was duty, breach, damages. I think that's the one, but maybe you've mentioned that elsewhere, is that your complaint should be very clear about what was the duty, how did they breach it, and what were the damages. And it seemed like kind of that was what happened in the utilities case, where you wanted the recording and conveniently they didn't have it. But why did he throw that out? Why? Because there was no damages, right?
That's correct.
You were going to let them. Now let's let them turn the power off. Fine, we'll just do this again. I'll let them damage me.
And it's funny, I wrote a letter and I sent it to the city, and let me just see if I'm willing to share that on this show. Let me just see here, because I
think that's more proof too that they just don't want this conversation out in the wild. With regard to your audio recording, the judge was not even, I'm sure it rolled up to him and they said, hey, he wants this recording, do you sign off on releasing that? And he's like, no, I don't want that in the public domain, especially this guy. I'm sure one of the aides came in and said, hey, do you know the guy that you just had in the courtroom got like this whole following on YouTube and like talks about
there was
this
like 10 or
stuff?
12 people there, and they were shocked. They're like, who's all these people? And are they witnesses? I was like, no, they're just here to watch.
So somebody Googled you, I'm sure, one of the aides, and then they reported back to the judge, and then by the time you asked for the recording, they're like, oh, hell no, for that to end up on his YouTube channel? No. Because if I remember, you said he kind of was a little resistant, but when you were going toe-to-toe with the facts, he kind of came around and said, okay, well, I kind of see where you're coming from, but there's no damages, so get out of here. So.
Yeah, I'm going to go ahead and show this letter. Give me just 1 second here. Let me just show this here. Actually, give me just 1 second here. Yeah, it is interesting. My round one with the city of Glendale was dismissed because it was in federal court, and I kind of fucked that up, and I couldn't get jurisdiction. So it was dismissed for lack of jurisdiction, because they put in a motion to dismiss because of a lack of jurisdiction, because there wasn't a federal question. So the only thing that could have been was diversity. I think I put diversity on there. Diversity means it has to be 2 different states, and it has to be more than, I think, 75,000 in damages for it to fall under diversity. So I just said, yeah, I can't win that battle. So I just kind of let that one go. And then I did, for round 2, I wanted to test small claims. So I filed a small claims case, which is all on Williams & Williams. I can show you guys for people who may not be familiar with it. Oh, whoops. Hold on one second. So if we go to current and previous litigation and we scroll down, you can see all the cases. So you can see the Glendale Utilities case, case number 5. This is the one that was dismissed for lack of jurisdiction. You can go in here and you can see all of the docket items on that. And you can see that I didn't really fight it. You can see I didn't really go to appeals because I just didn't see how I could possibly get it to work. So I went back to the drawing board and I decided I wanted to test small claims. I thought, what the hell? It's $80. It's super cheap. It's super easy. No one will ever give me a hearing. So with small claims, that's pretty much all there is a hearing. There's really nothing else. I mean, you file a small claims case and then bang, you get a hearing. And that's it. That's pretty much the whole process. So I thought to myself, well, shit, that'd be my first time in a courtroom because no one else will give me a hearing. So I went ahead and posted all that here. This is all the original docs here. And with the summons and all the good stuff, right? That's the one that was dismissed for in live in the courtroom with the judge. He was very impressed with my work. He was very impressed with my demeanor. He was very impressed with my presentation. He was very impressed with how well I knew the information. He was pretty shocked about the fact that this was even real, and I assured him it was. But then he dismissed the case for lack of damages. That was really what he dismissed the case for, right? So what I did was I sent them a new letter. I just sent them another one with a new bill, brand new bill. This is the letter that I sent to them. Letter accompanying endorsed original drafts tendered for payment in accordance with the California Commercial Code Division 3 on behalf of the sole proprietorship. Same thing. Important note, the enclosed draft is endorsed in blank, meaning payable to bearer. Please be sure to use the same protocol as you would to handle it as you would for cash, as this draft is legally cash. As cash is defined as a negotiable instrument that has been endorsed in blank. Dear Payment Processing Center employee, enclosed is one endorsed original draft that is being tendered in good faith for full satisfaction of the original claims. This is in accordance with the California Commercial Code Division 3, Section 3311. We just completed a small claims case. The hearing was on 8/7/25 at 1:30 in Department A at the Pasadena Courthouse. I was there in person, and Holly Ederly Allen was there via Zoom. I presented my case in accordance with the California Commercial Code, and the case was dismissed not on the merits, but due to lack of damages. For that reason, I am willingly and knowingly not going to make an online payment like I typically do, but will only be tendering this endorsed instrument. Then, if the power is turned off for absolutely any reason, a new suit will be filed that will be listed as the damages on the suit, with that as the damages on the suit. I am working on getting the audio file from the hearing as well. If you would like a copy of it, once I get it, please just let me know and I will send it to you. You will see that the endorsement is a red stamp with blue signature on the face of the instruments. For clarification, I will type the endorsement in text here. Phone number, and then I will presume in accordance. Now, this is really, really powerful. This is something I recently found. I don't know if you saw that I found this. This is huge. I will presume in accordance with Division 1, Section 1206 of the California Commercial Code that this draft will be processed or dishonored. If this draft is dishonored around the due date, please allow me additional time to correct it. This is legally a payment as defined in Black's Law, which states the definition as the fulfillment of a promise or the performance of an obligation. The original draft is being sent certified mail rather than registered mail because both P.O. boxes are in the same post office and very little security is needed to deliver these to you. So I'm going into the post office physically that has the box of which I'm sending mail to. So they literally take it from my hand, they walk 10 feet and they stick it in the box. So I didn't use registered mail, but I want people to understand that you're supposed to, just like you did, you're supposed to use registered mail. I just figured it was a bit silly because it's like you don't need. What do you need security for? They're going to walk right over there on their go into the bathroom. They can stick it in the box. So that's. I want to be clear. That's the only reason why I use certified mail. I don't recommend that you use certified mail unless you're walking into the same. If it's the PO box is the same PO box in the same freaking post office, then I would just use certified mail. But that's just my own personal. That's just my own personal thing, right? So. With that said, the most important thing that I found recently is UCC 1-206, which we'll be getting into more and more as we go forward, right?
Presumptions. Yep.
So whenever the Uniform Commercial Code creates a presumption with respect to a fact or provides that a fact is presumed, the trier of fact, meaning the judge, must find the existence of the fact unless and until evidence is introduced that supports a finding of its non-existence. So this is the first time we've found something that basically allows you to wrap your hand around the judge's balls. Because it basically tells the judge what he's supposed to be doing. So it basically becomes a duty to the judge. So you can almost read this as the law states that the judge must find the existence of the fact unless and until evidence is introduced that supports a finding of its non-existence. This is fucking huge. And I just barely started implementing this. So I'm just waiting for them to turn off my power. And if and when they do, I haven't heard anything back from them. I've gotten no letters back. I sent this letter on August 25th. Like immediately when I got the bill, I was checking my mail every day. I'm like, I need a bill. Finally, they sent me one. Perfect. I wanted to get it in the mail literally immediately that way because I think the cutoff for my bill was like the 9th or the 10th. So I'm about 3 or 4 days past now. No calls, no letters, nothing. Power's on. So I don't know if they're trying to figure out what they're going to do. I don't know if they're going to just leave me alone from now on. I don't know if they're just never going to send me a bill again, or they're going to turn my shit off and then we're going to state court. I don't know what. Yeah. So I have no idea.
Do you have an online account where you can see if they've applied the payment or if there's any negative balance or no?
I mean, when I send shit, I don't really care. It's just like I send it, it's paid, and then now you guys are going to do whatever you're going to do. You know what I mean? So, but I'm gonna for this next round, if they do turn off my power, it'll be glorious because then I'm gonna have the damages that I need, and then we're gonna go to state court, and then that UCC 1-206 presumptions, it's going right at the very top in bold letters on the entire complaint. You know, the following cause of action is by law. Will be handled in accordance with by any justice associated with this case in accordance with UCC 1-206 or the state version of UCC 1-206, which states quote bold, and then I'm going to put the actual. And every time anybody says literally anything, I'm just going to redirect back to 1-206.
Right. Which says you have to believe what I'm putting forth because no one else here is saying that that's not the case.
Unless you guys prove that the judge doesn't. The judge is going to be constantly looking to try to essentially anything involving the UCC from now on. The judge is basically has a duty to basically look for evidence to the fact of what I'm saying is true unless the defense provides evidence that forces him to not look for the evidence. Mm-hmm. So what it's going to do is it completely flips the game. It's like when your dog shits in the kitchen and you shove his face in it. UCC 1-206 is basically like you can use it to shove the judge's face in the dog shit, essentially. So
wonderful metaphor.
I'm very excited about that, and we're just starting to implement that a little bit, and you're going to see that become a real centerpiece on a lot of these things. So
Nice.
You saw it in the letter I just sent too.
Yep.
So it's in the letter. So yeah, we're just going to keep trucking. We got a bunch of other people that are kind of in the middle of all this kind of stuff. Just waiting for David and Gabrielle and a few other people to wrap things up. And then we're going to bring them on the show. But you are the first one. You are the fastest one. You definitely had the easiest time. So yeah, congratulations. This is
Thank
huge. I don't want people to necessarily. I brought Paco on my show 2 or 3 years ago at the very beginning, and I think one of the mistakes that I made was making it seem like it's this easy, and I don't want people to think that it's necessarily going to be this easy. I think the reason why I wanted to do this show was because I wanted to show people it could possibly be this easy. I would say the chances of that is pretty slim, but I think one of the reasons why it was so easy for you is because you were so prepared. I think that's really one of the main elements. Because
Yeah, if I could do it different, I would definitely have followed your advice, or at least tried to rescind the arbitration ahead of time. Like I really wanted to have the merits of the case in court. I wanted to be able to try to have that argument to get some validation, like, is this how it works or isn't it? And they didn't want to go there. The court didn't want to see my side on that there should be no arbitration agreement. They're like, no, regardless, the arbitration agreement stands. Neither of you argued the validity, so it must be valid. Go to arbitration. And then even still, the bar card didn't want to do that. So, yeah.
Yeah, I think the fact that you're willing to come down and it was just so easy for them to just get off of it without having to talk about it.
Yeah. It inspired me to want to do it again. Now I want to go sign for a new car and avoid the arbitration clause and then tender a payment and try to have this actually discussed and taken all the way through and either get a yay or nay from the judge on is this how it works or not. So I think that'll be the next milestone for somebody.
Well, if you
whether it's
don't
me or
waive your right
somebody
to a
else.
jury, it would go in front of a jury. It wouldn't be in front of a judge unless
Got
you waive that right to a jury. I mean, the ultimate win on this would be jury trial. But I don't know. I feel like winning this in front of a jury, in my opinion, would be super easy. I don't think it'd be very hard because they don't like banks and they don't like attorneys. And I would just spin the whole thing to be, you've always wanted to fuck the banks. They've been fucking you your whole life. You've always wanted to fuck the attorneys. They've been fucking you your whole life. Well, I am your guardian angel. I have arrived. Today is the day where you're going to be able to bend over and fuck the banks. Congratulations. And I would start off my opening talk to the jury would be that, and then it would also be the second part of the opening opening talks or opening brief or whatever the fuck it's called would be, I know it sucks that you guys got picked for jury duty. I know most of you have families and jobs and you're probably not thrilled to be here, but I want to let you know you hit the jackpot because by the time you guys walk out of here, each and every one of you, I'm going to teach personally how to have infinite money and literally have all your bills pay for themselves. So I want to just let you guys know right up front, you guys hit the fucking jackpot. So, if you guys are upset, you guys are sad about being here, don't be, because I promise you, I'm about ready to change your life in a way that's so fucking dramatic, it's going to blow your mind. This is going to be one of the best things that you've ever done is take the jury on this fucking case. So that's how I would really start the deliberations on the jury.
Yep. Yeah, it's got to be costly for a point, for the defendant to go through and pay a bar card for a whole jury trial. Like, man.
Well, jury trials can be super, super fast too. I mean, I'd probably close out a jury trial same day, next day, easily.
Interesting. Okay.
You when you think of a jury trial, you're thinking of like criminal cases, O.J. Simpson's, this kind of thing. But something like this, you explain negotiable instruments, they say some bullshit, you rest, they deliberate, sometimes 5 minutes, 10 minutes, 15 minutes, half an hour, 2 hours, maybe until the next day, whatever, and then they come back and then bang, it's done.
Got it.
Jury trials can be
Interesting.
super
Yeah, I didn't know it
fast.
could be that fast.
Yeah.
Yeah, I thought it might drag out.
It could. It could.
I imagine the discovery part, that's where I guess I envisioned that
So
potentially
discovery is when
dragging
you're
out.
digging up and preparing the evidence that will be presented at the trial.
Yeah.
So you're digging and digging and digging. You're finding those little nuggets, and then you get to take them away and clean them up and organize them, and then you get to file into the case to get certain items filed into evidence, and then the judge determines what can and cannot be filed as evidence, and then everything that's filed as evidence into the case becomes evidence that can be submitted to the jury. So the judge becomes the filter point between what can become evidence and what cannot become evidence for the jury. That's essentially discovery in a nutshell, right? So that's what you'll see on TV shows and stuff like that. They'll try to present evidence to the jury, and then they'll get shut down because that evidence wasn't previously submitted for approval through the court to be submitted as evidence. And then at that point, that's when it can be used with the jury.
Yeah, got it. Makes sense.
So that's where the public versus private comes into play too, because you're digging up all this stuff. You may only want to submit 2 pieces into evidence. So there's 25 pieces of gold or 23 pieces of coal, 2 pieces of gold. You're going to take those 2 pieces of gold and you're going to write those into be submitted into the evidence. So those 2 pieces kind of go back onto the docket into the public, but the other 23 pieces are never submitted back into the court onto the docket. So you have this kind of public-private going back and forth, back and forth, back and forth, and you decide. And then they don't want to answer a question, and then bang, now you're back on the docket. Motion to compel. They answered number 1, 2, and 3 just fine, but then on number 4 they balked real hard. This is what happened. I need a motion to compel, or they're going to be held in contempt. And then he says, yeah, and then they go back to the privately answering these questions, blah, 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 blah. And then after that, then you decide what you want to do. So I haven't gotten that far yet. I haven't gotten very far at all, but I've been studying all this stuff in preparation for the day that it happens. So
Nice. Definitely rooting for you. Couldn't have gotten this far without your material and the way that you've presented it, and then you're just
and so many people are
tenacity
scared
to-
about going into court and being on the phones and all this stuff. I mean, the fact that you didn't have to do any of that is super cool. I mean, I try all the time to get hearings, and they always get denied or canceled. They don't want to talk to me.
Yeah, my only experience in the courtroom is really the family court stuff, which I honestly I totally agree with you that like they don't follow the rules. It's total bullshit. I've experienced that stuff for myself, going in there and trying to argue jurisdiction, use the magic words, and you get mowed over. And so, luckily, I was able to come out on top with some of my family court stuff, but it was not without some effort and trying to play by the rules. Actually, in some cases, when I realized that the other methods that you thought would work from this material that we see is like it doesn't work, and they don't acknowledge any of it. It's definitely a corporation. It's just a business that has its own rules. They're not a real court, so I can definitely attest to that. So I've been in the courtroom before trying to argue that stuff, but that's the only time.
Oh yeah. Have you seen Divorce Corp, the documentary?
Yep. After you recommended it, I was like, how have I not heard of this? I ended up watching it 2 or 3 times. I've recommended it to a couple people, but it made so much sense about how the lawyers are motivated to keep the process going forever. And the court is under no requirement to behave like a real court, so they can literally just do whatever they want. And that doesn't bode well for us who are trying to do the right thing and get some progress and some acknowledgement of what the facts are.
Hell yeah. All right, brother. Well, anything else you want to say, or anything else you want to add to this, or any recommendations, or any other plugins, or anything else you want to plug in or say, or before we end off on this?
Yeah, maybe just a reminder to everybody that if you're going to go down this road, try to at least get rid of the arbitration clause, or be astute enough to sign that, scratch it, novate it out of your contracts, or rescind it as soon as possible, and get some proof on the record that you've challenged the validity of the arbitration agreement, so that you've got a better chance in having this argument stand and be sustained in court.
Yeah, I
I
just
got
sent him a
kind of lucky
letter.
because I wasn't prepared, but I navigated around it.
I just sent him a letter, a month or so before I filed the complaint, let them know that, all previous arbitration agreements are hereby canceled and all rights are hereby reserved, in accordance with UCC 1-308. This includes, the right to a jury trial. This includes the right to discovery. This includes, any other rights that may be whatever. I just put that in the letter like a month before my complaint gets filed, and I've never had anyone try to force me into arbitration. So
Excellent. Yeah,
even if there
that's
was a
inspiring.
30-day whatever, blah, 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 even if there was,
That shouldn't matter.
I
Yeah.
never even
Okay.
checked. I just
Okay.
sent him a thing, fuck you, not doing it. And that was enough to not ever have the issue. So,
So they just never brought it up then
no,
after you've done that. They never even tried to say that there was
never in
interesting.
any case I've been associated with or done myself have I ever had to come up against an arbitration clause. Joey has,
Cool.
but I have not. So,
Okay.
and all I've ever done is just say fuck you. Everything's reserved. All rights are reserved without prejudice. And fuck you. There's no arbitration clause. And
Yeah.
I'm building a lawsuit to sue you very soon.
Yeah. Cool. Yeah. Stressful as it was through all of it, the zigs and zags, I still kicked myself and said, this was fun. It was a healthy kind of challenge, and I should have done it before. I should have done it sooner. Why did I wait so long to start this and file the case? I was just, nervous for all the wrong reasons probably. And there's plenty of information out there now and resources to get started in the right direction. And if you're thinking about this, don't wait. There's no reason to wait. Just jump on and cut your teeth with. Maybe you'll lose the first time, but I'm jazzed about doing this again and being even more prepared this next time on the next vehicle or a house or whatever. So I think we have proved and established that there's something here. We're over the target. This is an argument that you just don't want to have, and they're at least a little bit intimidated by it. And we're pro se. We got all the time in the world. It doesn't cost us anything to go file motions, yet it's counterproductive to the client's interests. Every time the bar card has to respond to us, no matter what we're putting in the record, bar card has an obligation to respond, which cha-ching, cha-ching, cha-ching works against the client's interests, right? So use that to your advantage. I think that's probably what worked for me.
Oh yeah, brother. Well,
Yep.
thank you very much for having me on the show. Thank you for everything, and we'll sign off.
Yep. Thanks, brother. Appreciate it.
See you later.
Later.